involves two documents, and several documents, but the two key ones are the decedent Nathan Etheredge's will. Sorry, I'd like to reserve 3 minutes of rebuttal.
3 minutes, yes, sir.
Thank you. Nathan Etheredge's will from 2015 and a 1989 postnuptial agreement. Key to all this, though, is Mr. Etheredge. Larger than life is a good word for him. And Banny Rooster, I don't know if y'all are familiar with that term, but he was much larger than his physical stature. He grew up in humble beginnings in Alabama, ran and then owned some factories back when there were shirt factories in Tennessee. He ran them and built a fortune from very humble beginnings. He had two families. He had his first family, which are the 5 Applees in this case. They're the children from that first marriage. And then he had a second marriage, 40 years with Ms. Doris Etheredge, who I represented until she passed. And I now have the pleasure of representing her son and her daughter, who are the appellants in this case. Mr. Etheredge, I want to start with the will. Mr. Etheredge made a will in 2015 that specifically disinherited his own children. He states in the will, this is in the record, that for reasons that are known to them, that he has, and after long thought and consideration, that he was making this decision. And he signed the will. It's executed. It's duly witnessed. It is incontestable. The time to contest it has passed without any contest being filed. On the same date and time, his wife of nearly 40 years, Doris, signed a similar will that mirrored these provisions, also similarly disinheriting Mr. Etheredge's children based on his decision. 3 years later, 2018, Mr. Etheredge, after not too long of an illness, passed away. And there was one document that had to be probated. And they hired a noted local probate attorney back home, Dale Bohannon, to probate it. And out of the blue, at least as far as Ms. Etheredge was concerned, this 1989 document appeared. The case is here on cross motions for summary judgment, so it's a de novo review. We have put all the factors in the record. I believe Mr. Michaels and I, he's been good to work with on this very challenging case. For a lot of reasons, I believe our esteemed Chancellor, Ron Thurman, made the wrong decision here. And there's a lot of reasons for that. Number one, it's a central principle of Tennessee law that the intent of the testator is to control the disposition of his estate. That's a guiding principle that goes back almost as long as their decisions, not just in Tennessee, but
that's to interpret or construe a will. The question here is contract.
Well, there is a contract component, but there's also a will component because the documents were all before the court, and we can't construe the contract, I would submit, without construing Nathan Etheredge's will.
Well, there's no dispute what the will says. It's unambiguous. Correct. And there's no dispute what the contract says. It's unambiguous. So we don't have to construe anything to find intent.
Okay.
The question is, does the contract control the disposition of the estates?
Right. Well, and there are technical defenses to that, but the biggest mistake, I think, the biggest equitable problem here is the failure to honor Mr. Etheredge's intent regarding his own children. That's the fundamental problem we have here. Now,
can I ask a foundational question?
Of course.
Are we here in connection with the right will? And under the terms of the 1989 contract, the money is supposed to pass to Mrs. Etheredge, which is what happened here. Mm-hmm. And so whether the 1989 contract is in place or not in place, exactly what was supposed to happen under Mr. Etheredge's will occurred.
Yes.
Doesn't the challenge need to be in the context of her will rather than his will?
I agree with that. And I think that mooted the issue in the lower court. However, she's now died. Her will was not part of the underlying case because I believe she died after the court had made its decision. And there's some collateral proceedings that are not before this court related to that. But I agree, Mr. Etheredge's will left everything to Doris Etheredge, and
which is what was provided for under the 1989 agreement, right? I mean, that's what was supposed to. Okay.
Yeah. Now the question itself, it was moot when it was decided by the judge, but since she's passed, it's very much alive. I don't know procedurally it's properly here or not, and I leave that to your Honor's wise discretion about it. But your question's right on. It's with regard to Mr. Etheredge, it all went to Mrs. Etheredge, and the whole second to die issue was prematurely decided by the court, and we could end there and go from there. But there are more fundamental problems with that 1989 agreement. Number one, there's no one alive who can authenticate it, who can testify about it, who can prove the foundation to get it in.
But on the authentication end of it, I mean, it is a notarized document, so what would be, I mean, that's presumptively authenticated under statute. So was there some testimony from Mrs. Etheredge while she was living that says, I deny this is my signature, or something to overcome that presumption, I guess is my question.
Well, and a point in my understanding, and it's been a while since I looked at this particular law, was it not in order for that presumption to kick in, it had to be authenticated and recorded. This was not recorded. The self-authenticating provisions of the evidence rules, I don't believe, work just for a notarized document. There has to be something else to do it. The record is silent as to Mrs. Etheredge's position regarding the agreement. They had the burden of coming forward and proving that this is their agreement, that this is binding upon them, that they signed it, all the basic things that you have to prove whenever you're proving your contract case. Again, they're not parties to the contract. It's a third-tier problem with this issue, but it's a problem.
Well, they're the third-party beneficiaries.
They were in 1989, but the intent of these parties, Nathan and Doris Etheredge, changed as reflected in their wills. They did not intend them to be third-party beneficiaries after 2015.
But doesn't the contract say it has to be amended in writing, signed by both parties? And the gentleman's will was not signed by the widow.
The recitals claim to put that procedural requirement in there. That is what they argued. Obviously, the decedent's, Mr. Etheredge's will, was not signed by his widow. Now, her will, that does the same thing, obviously was signed by her.
Counsel, what about the language in terms of, returning back to the 1989 contract, a separate written agreement? Part of opposing counsel's argument is that the language, the whereas language, means it can't be in the context of a will. Why is that wrong? Why is that a wrong interpretation of the separate written agreement language of the 1989 contract? Doesn't it have to be outside of a will, some sort of other type of document?
That agreement doesn't have to be in writing. That agreement just has to be reached by the parties, the same way an oral agreement, that any other contract can be enforced. It doesn't have to be in writing. The wills reflect their agreement.
Well, I mean, I'm reading language here from the 1989 provision: desire this agreement to be irrevocable in the absence of a separate written agreement between the parties that specifically revokes this agreement, that shall be signed by both parties in the presence of two witnesses and a notary public. And that seems to suggest you have to have some sort of independent document in order to revoke this 1989 contract. I'm struggling to understand why that's how you can do this through a will.
Sure. Well, again, it says there has to be an agreement, right? So we have an agreement. The other factors come in. Now, the recital attempts to say it cannot be done through the will. But when you look at the 1989 agreement in pari materia with the wills and with the conduct of these parties over the years after this, when you look at all that, the issue then becomes, does that particular procedure become the only way in the world that these parties can change their mind about where they leave their estate? And I don't think that's the law or even the impact of this agreement. The procedures that are in there were clearly intended to make it where it could just happen by happenstance. The intent of that agreement was so that the second to die couldn't ride out the other side's children. That's the clear intent of it. Mr. Etheredge, though, decided to write out his own children.
Counsel, with regard to your full disclosure arguments that you've made with regard to the 1989 provision, were those raised before the trial court in responding and addressing the summary judgment questions in these cases? So you put those issues, those arguments before the trial judge? Yeah,
it was a key part of all our arguments down there because it didn't match the statute, 365301 or 3501. But it didn't, there was no proof that this had been knowledgeably entered into by either of these parties, in particular Mrs. Etheredge. And we've argued and briefed the matter about what's required for knowledgeably, and my opponent's argument is fixated on whether it's post or ante-nuptial agreement. Well, the Supreme Court in the Bratton case made it clear that post and prenuptial agreements are interpreted similarly because the spouses owe fiduciary duties to each other both before and after the marriage, right? They owe it to it in the agreement per statute, and then they owe it afterwards because they're married. And so the burden under Tennessee law with regard to these agreements is on the proponent to show that they were knowledgeably entered into. They can't do that because the two people that enter into it are no longer with us. There's no discovery done on them. There's no questions asked. There's no proof of what they knew or what they didn't know. This was raised to the trial court. It's one of the specific findings I believe we asked him to make. I'm out of time, but I'll have I will know for sure when I stand back up and be happy to answer any other questions.
Thank you, Mr. Fincher.
Thank you, gentlemen.
All right, the appellee, Mr. Michaels. Good afternoon.
Afternoon, Your Honors. Charles Michaels on behalf of the appellees. As noted and as you're all aware, this case is about the 2015 will and whether it was sufficient to revoke the 1989 contract. Appellee's position is to uphold the trial court's decision that the contract could not be amended by the 2015 will. The two main issues that in appellee's opinion are the main deciding factors in this case are whether a contract to create a will, which states that it can't be revoked by a will, can then be revoked by a will. And second, whether a will can revoke a contract when the contract becomes irrevocable upon the death of the testator and the will doesn't become effective until it's been submitted for probate.
Counsel, can I ask you the same foundational question I asked to opposing counsel? Are we here under the right will? And it seems to me that with regard to Mr. Etheredge's will, whether the 1989 contract is valid or not, his will had the money do exactly what it was supposed to do, whichever side is right. Isn't it Miss Etheredge's will that's really where the sort of dispute lies in terms of whether she can disinherit the 5 children from the previous relationship?
It's a great question, and I actually argued in my brief that the fact that everything did go to Miss Etheredge meant that his will did actually comply with the contract. But to your point and your question, and from my client's perspective, there were potential issues with statute of limitations, waiver, and all sorts of other things that made them feel like this was the time to bring the claim. But generally, yes, I mean, I agree with your statement. It could have been brought, I think, in either one, because we're dealing with the contract and not the will, and we're seeking a declaratory judgment as opposed to going out right front and saying these are the damages we're entitled to. It was an action to determine whether the contract was valid in light of the 2015 will.
This is a question that may address justiciability questions that may be beyond, or certainly beyond the record here, but is there a challenge that's been brought to Miss Etheredge's will?
There is, yes. Pending will contest.
So this action is a petition for declaratory judgment.
Correct. Yeah, there was a request for damages, and the court's judgment was certified as final as to this issue, and the court did leave open the damages issue, but again, we are still going through and pursuing it through the estate of Miss Etheredge, because that's probably the proper procedural course. Going back, and appellees, many of their arguments, as I'm sure y'all will know, are based off the 2019 case, In Re Estate of Hunter. The main fact in that case that I can see is potentially differentiating from this case is that, you know, it was a trust, and the assets there were put into the trust. My position when looking into that is that much of the court's focus was on whether the trust itself could be amended or revoked by a will. There wasn't as much emphasis placed off on whether the assets were actually placed into the trust. I presume that's because the trust was revocable and he could have revoked it or moved any of the items before he died, and that's what the court, at least in my opinion, again, believed that Mr. Hunter intended to do prior to his death, was move those assets, at least to not allow those assets to pass through his trust, to instead pass under his will. And as you all know, the court said, your trust says you have to amend your trust by doing this. Your will can't amend your trust. And you've been doing this you've done this a number of times. You've amended your trust a number of times, and each time you've signed those amendments as the trustor and the grantor, or the trustee and the grantor. And when you amended your will, you just signed it as yourself, not as the grantor. So because of that, you didn't comply with the terms to modify the trust.
Counsel, what's wrong with opposing counsel's argument that the same requirements with regard to disclosure apply pre and post nuptial agreements? Why isn't that right?
There is a footnote in Bratton that references that, lack of a better way to put it, the control of one's assets after their death with their spouse is sufficient consideration for could be sufficient consideration for a postnuptial agreement. And just as to whether you need the disclosure itself, I mean, that's a statutory requirement, as I understand it. And so Bratton didn't extend that statutory requirement to a postnuptial agreement. Instead, when it referenced the postnuptial agreement, it said that could be
Did the trial court rule on that argument in this case?
It did, yes. I can't remember the specific finding of fact, but I believe it was along the lines of Bratton relates to prenuptial agreements, as does the statute. Your Honor, was there another follow-up question on that? I don't want to speak while you're flipping through.
Well, I guess on the relief request in the deck action, so when the chancellor granted the summary judgment, he said, motion for summary judgment is granted. The 1989 agreement controls the disposition of decedent and defendant's property that is subject to the agreement, and plans are entitled to damages or specific performance. So when they're talking about Mr. Etheredge and the defendant's property, I'm assuming Miss Etheredge in that case. So what's going on in Mrs. Etheredge's estate other than saying, here's the deck action judgment? Aren't we finished here? I mean, What's more to be done with that sort of judgment?
There's discovery of assets, but as you just stated, I believe it's a res
Controlling,
judicata or
I see.
collateral estoppel issue,
Yeah.
one or the other.
Well, assuming this becomes final.
Assuming that,
Yeah.
correct. That's how it was filed in her estate, so as to not.
And so on the issue about the validity of the agreement, so that part of the undisputed facts here, as I understand appellate's arguments, and I'm sure Mr. Fincher will correct me if I'm wrong here, is that there is really a contest still about the validity of the 1989 agreement. The chancellor mentions in its judgments two things: the signature, which I would tend to agree, the signature is probably not an issue because of the notary. In consideration, there was a presumption there. But to Judge Usman's question about, whether or not there needed to be a full disclosure of what assets we're talking about and how you could ever have that, how was that resolved? Was that ever actually raised in opposition to your motion for summary judgment?
Yes, it was raised.
Okay, and how was that disposed of?
Again, I don't have it in front of me, but I believe it was along the lines of, and I believe that's what's required by the prenup statute as opposed to.
I see. And so they just said that wasn't relevant because
Correct.
It's not, okay, all right.
Correct, it's not statutorily required.
Okay.
And looking to one other thing I did want to mention regarding this case in Hunter, Nathan Etheredge, he did, it was in 1995, 1999, 2003, and in 2009, he created estate planning documents that referenced the 1989 agreement, or specifically incorporated it, which is another factor that the court looked to in Hunter when it said that, a testator is presumed to know his estate planning documents and how the law applies to those documents. So that's the rule we're going to apply to Mr. Hunter's will, whether that was Mr. Hunter's intent or what he was attempting to do or not. And I'll submit that should happen here because, again, multiple times over the years, reference back to this 1989 contract. So if we were to say that the will controls and we just throw out the contract, we're essentially stating that he apparently no longer knew what estate planning documents he had in place, which would seem to be contradicted by the fact that over 20 or so years, he referenced those documents 4 or 5 times. Real quickly, I'll switch to the notarization issue just to hopefully clear that up. In my notes here, it says that there's an admission, or for the purpose of summary judgment, that both parties signed the contract. So while that issue was reserved for trial at summary judgment, I believe that's a moot point. And again, real briefly, one other issue that was raised was whether there needs to be a separate writing or just some sort of agreement to revoke the 1989 contract. The recital clause that states that a will cannot revoke the 1989 agreement seems to be pretty clear and should control that issue. Other than that, unless your honors have any other questions for me, I'll rest everything else on my briefs.
Hearing no questions, thank you, Mr. Michaels.
Thank you.
Mr. Fincher?
Yes, Your Honor. So, promise made, promise about to be kept. Was the issue of knowledge raised? It was raised in the briefing to the court, in the motion to the court, and in the motion for request for specific findings that the court, we contend, ignored. Number 4 of that says, did the 1989 postnuptial agreement contain any indication that the parties knew the nature and extent of each other's estate when it was signed? So it was raised. Now, how was it addressed? In understanding from a friend getting caught without the benefit of the record in front of him, I have the court's order drafted by opposing counsel that his brief says addresses this issue. I don't believe that it does. I don't believe that it addresses knowledgeability at all. It's paragraph 9 of the order. I'll read it to you. there's no evidence of inadequate consideration for the agreement, and defendant cannot overcome the presumption that all contracts in writing signed by the party to be bound, including postnuptial agreements, are prima facie evidence of consideration, Estate of Brown. Citation. That's it. Does not address knowledge at all. It addresses consideration, a completely different topic and issue, one that we haven't even raised. Was there consideration? The whole issue is, did it meet the knowledgeability requirement that under Bratton is applied? These agreements, post and ante-nuptial, are to be construed consistently, right? And the statute was applied in Bratton by the Supreme Court back in 2004.
Well, counsel, on that latter point, there's disagreement on that front, right?
Okay.
Opposing counsel says that they're not. You argue that they are, and your broader point is that the trial court didn't rule on that contention.
That's the biggest problem we have. He ignored it. He also ignored the question of Nathan Etheredge's intent, which is vital here. Can a document that has some arcane provision about how it's to be addressed override somebody's express intent reached later? Do you have to follow this weird little procedure to change your mind or to revoke it? And I submit to Your Honor, that's not Tennessee contract law.
But parties can create a method for the termination of an agreement, right? I mean, revocation. You can provide in your contractual agreement, we're going to terminate this agreement using a certain procedure.
Of course. But is that the only way that it can later be amended, changed, or revoked? His will revoked all prior wills and statements to the contrary. Her will did too. Does that, and I'm running out of time, the reason his other wills referenced it is it was done by the same Knoxville firm that had done the underlying agreement. 2015, he came to my office. I didn't do this other stuff. We didn't have it. Here we are. And so we're in a position of, is this agreement enforceable? For a lot of reasons it's not. Primarily, they can't make, they're showing that either of these parties had knowledge of the extent of the nature of the other person's estate. Just because somebody's married doesn't mean they know everything their spouse owns. I mean, it's what's that old country song about? I hold back a little on payday that you don't know I got. I mean, from the lowest economic strata on up.
I want you to know that declaration is being recorded in perpetuity on the internet.
Except anybody in this room, of course. I'm just talking about out
of course. You're just speaking of others.
Exactly,
Thank
always.
you, Mr. Fincher, and thank you, Mr. Michaels, for your arguments. We will take your matter under advisement. Before we hear the third case, we're going to take a very brief recess, and we'll be back.